So wonderful to be with you all tonight. For those of you who are regulars of the Dole Institute, this is kind of turning the tables in because usually here we have a student do the introduction and then we have the adults doing the program. And tonight it's completely different with me, Director Audrey Coleman, doing the introduction and welcoming you all this evening for our installment of the Counselors in Spring 2025. This is one of the most anticipated programs that we hold here at the Dole Institute, and is certainly one of our favorites, and we have a great event for you this evening. It's one of my favorite, not least because I'm almost totally superfluous this evening. These folks are doing such wonderful work. They're going to have a really engaging discussion. I want to acknowledge our friends and visiting fellows, Ed Duckers and Pedro Irigonegaray. These two folks have been hard at work mentoring our students and working with our experts. They've been a part of this program for many years. I'm going to say like cumulatively over 25 years. We'll just kind of leave it at that. But we reinvented the counselors and neutral ground with student engagement component a couple of years ago, and it's been a wonderful, wonderful success. This is an outstanding showcase for our students here in the Student Advisory Board and also with our friends from Washburn Law. We're so pleased you all could be with us this evening and really looking forward to hearing from you. And we share the Dole legacy, obviously, here at the Dole Institute and with Washburn Law. So that means an awful lot to us here. I want to thank Dean Jackson for being with us this evening. Thank you so much. Give him a wave. Thank you. And our expert witnesses, I'm not going to introduce you because I'm going to let Nathan do that here in a moment, but we are so grateful for your time and energy and effort being with us. I hope you have a great time. We're certainly set for a really wonderful conversation. Again, this program has been a staple of the Dole Institute since 2008. We decided, I remember 2010, but 2008, topics all across the board. More recently, term limits for the Supreme Court, some big tech monopolies, dealt in issues related to criminal justice, and a great variety. So this evening, when we're talking about medical assistance in dying, is just our latest installment of very fascinating and complex topics that this milieu, to lack of a better word, really assesses very nicely. I want to thank Sarah Stacy for coordinating all of this. Give her a big round of applause. She is in the back. And I won't take any more of your time. I'll turn it over to Nathan Binshtok, who is our moderator this evening, and will introduce our panelists. Nathan, take it away.
Well, thank you, Audrey. At this time, I'd like to ask everyone to please silence their cell phones. Good evening, and welcome to the latest installment of The Counselors. The Counselors is a courtroom-style debate over an important issue. This year's program and topic is Should Medical Assistance in Dying be Legal in the United States? I will now introduce our participants. The affirmative case will be advocated by Counselor Pedro Irigonegaray. Mr. Irigonegaray is an attorney and partner at Irigonegaray, Turney, and Revenaugh. The experts for the affirmative case will be Jaspreet Chowdhury, Senior Legislative Counsel at Compassion and Choices, and Diana Bernard, the Associate Professor of Family Medicine at the University of Vermont Medical Center. The university students involved in preparing the affirmative case are Janira Silva, a second-year law student at Washburn University School of Law, and Cass Kasmus, a KU senior and SAB member majoring in philosophy, along with Ava Levin, a KU freshman and SAB member majoring in political science and Spanish. Moving on to the negative case. This will be argued by a counselor, Ed Duckers. Mr. Duckers is a partner at Stoll Rives LLP and the head of the firm's litigation practice in California, as well as a member of the firm's executive committee. The experts for the negative side will be Jason Ribley, philosophy professor at the University of Kansas, along with Michaela Prezia, a coalition coordinator for the Patients' Rights and Actions Fund. The university students involved in preparing the negative case are Ryan Peterson, a third-year law student at Washburn University School of Law, Jaspreet Kaur, a KU sophomore and SAB member majoring in communications, and Harini Srikanth, a KU junior and SAB member majoring in political science and philosophy. The rules of the counselors are as follows. Each counselor will present their case and must follow the time constraints for each set of arguments and cross-examination of witnesses. We have our timekeepers here on both sides who will hold up cards letting each side know how long they have left. First, each side will have 5 minutes of their opening statements. Next, each counselor will have 24 minutes total to ask their expert witnesses questions to build their case. First the affirmative, and then the negative case. During cross-examination, the opposing counselor will have 16 minutes in total to cross-examine the opposing side's expert witnesses. They may choose to split up this time however they would like, and the timekeepers will let them know how much time they have remaining. Lastly, each counselor will have 5 minutes remaining for their closing statements. Counselors, when your time is up, please conclude your speech in a timely manner. Now, without any further ado, let's begin the program. I welcome Mr. Irigonegaray from the affirmative to make his opening statements.
Good evening, and welcome to our program. Medical aid in dying refers to a practice in which a mentally capable, terminally ill adult may request from their medical provider a prescription for a medication that they can self-ingest and die peacefully. Today, in the United States, 1 in 5 of our fellow citizens have access to this process. The practice protects patients, upholds individual autonomy, and improves the quality of end-of-life care. Medical aid in dying is entirely optional for both the provider and the patient. Nobody is forced to participate, and the availability of the option brings people comfort during the very last part of the dying process. It is not suicide. It is not euthanasia. Allow me to explain. Suicide is a public health and medical concern which requires collective efforts to address. Euthanasia is an intentional act by which another person, not the dying person, acts to cause death. Euthanasia is illegal in the United States. Medical aid in dying is available only to terminally ill adults who are mentally capable with a prognosis of 6 months or less to live. The person is in charge of the process from the initial request to self-ingestion. Additionally, there is no substantiated correlation between medical aid in dying and suicide. When medical aid in dying is authorized, it increases the likelihood that a terminally ill patient will express their desire to end their life to a medical provider who has the training to evaluate and connect them to appropriate care and support. Further, data shows that medical aid in dying laws improve the end-of-life care in general and hospice and palliative care specifically. Importance and connection to right to engage in end-of-life decision-making. Medical aid in dying is consistent with a recognized right to engage in end-of-life decision-making. Mentally capable adults have a fundamental right to determine their own medical treatment in accordance with their own values, beliefs, and/or personal preferences. And having the option of medical aid in dying is an expression of this fundamental right. Authorizing the full range of end-of-life options, including medical aid in dying, allows people to engage in open conversations with their health care providers, their loved ones, and their leaders and faith leaders about the end-of-life experience. The availability of medical aid in dying provides an additional end-of-life care option for terminally ill individuals who seek to retain their autonomy and some level of control over the progression of their disease as they near the end of life, or to ease unnecessary pain and suffering. Medical aiding dying is not right for every individual, but its existence leads to better conversations around the end of life experience in general. Medical aiding dying is part of a general medical care and complements end of life options such as palliative care and hospice care for individuals to have an end of life experience aligned with their beliefs and values. Integrating medical aiding dying. My time is up. I had a lot more to say. I'll get back with you.
Thank you, Mr. Irigonegaray. Mr. Duckers?
Thank you, Pedro. I'll say it for you, okay? Voluntary euthanasia, physician-assisted suicide, medical aid in dying, medically administered death. They're different terms that describe exactly the same thing. Doctor-prescribed death. To claim that what is advocated for by the proponents of this proposition is not suicide is disingenuous at best. A person goes to a doctor, probably not his or her own doctor, because at least in Oregon, 98% of doctors will not participate in this activity, and almost a third of lethal prescriptions are written by 3 doctors who have set up a cottage industry in prescribing death to their patients. The doctor, with no training in psychological evaluation whatsoever, checks a box that says, this person's mentally competent, this person asked to commit suicide, and I prescribe this person lethal drugs. That's what we're talking about. Now, there are certainly circumstances, and you will hear about them from the experts on the other side, where that seems merciful. But there are many circumstances where it would be merciful to which this does not apply. And because of that, there is no way to erect guardrails to prevent doctors prescribing death from covering circumstances that you and I would never favor. I will be privileged today, and you will too, to have our case presented by 2 outstanding students, Jaspreet Kaur and Ryan Peterson. Jaspreet is a sophomore majoring in communications. She's an SAB member, and she was our assistant last year who's now taken a leading role. Ryan is a third-year law student at Washburn who has excelled so exceptionally in his career in law school that Pedro hired him. And he will start working for Pedro in August. In fact, he's been clerking for him this past semester, secretly gathering information for our case, which just goes to show you what an excellent lawyer he's going to be. They will present to you 2 expert witnesses, Jason Ribley and Michaela Preza. Jason is a professor of philosophy here at KU with expertise in medical ethics, moral psychology, and value theory. He's going to testify that while he is sympathetic to the terminal patient who may wish to end his or her own life, there are real concerns, both in practice and looking forward, about the efficacy of guardrails that we attempt to construct around the practice of doctors prescribing death to make sure that it is not abused. He also has concern about pressure. If you make medically assisted death available on a widespread basis, there will be pressure put on those who may be terminal to exercise that option. And that pressure might come from family, it might come from internally, or as we have seen so far in practice, it may come from insurance companies who do not wish to provide coverage for the treatment that might extend a life, but instead are more than willing to direct the patient over here to column E, which is doctor-prescribed death, and to let them know that that is covered by their insurance plan. Our other witness, and I would say also, and both of our witnesses will speak to this, there is virtually no assessment of mental competence when someone goes to a doctor who may not be their own doctor and says, I wish to commit suicide. You have to fill out a 4-page form before you can try someone assessing their mental competence. They have to be evaluated by a psychiatrist or people with training in mental health. If you want to go ask a doctor to assist you in committing suicide, you can go to anybody and they check a single box saying, in my judgment, this person's competent, and that decision is not reviewable ever by anyone. Michaela Prezia is the Coalition's coordinator for Patients' Right Action Fund, an organization committed to fighting assisted suicide and protecting vulnerable populations who might be taken advantage of if this were the law across the nation. And she will testify to all of the problems that have actually been experienced in the 11 states that allow for medical assistance in death or doctor-prescribed death, including, hopefully, there is a doctor in Colorado, which is one of those states, who is a specialist in eating disorders, who has decided there is such a thing as terminal anorexia. So young people with an eating disorder might go to this doctor, be diagnosed as having terminal anorexia, and be given a set of pills to take his or her own life. That's the danger we face in crossing the Rubicon. Allowing doctors to prescribe death is a line that we can never cross, and we will put that case on for you tonight and ask for your vote at the conclusion of the program. Thank you.
Thank you, Mr. Duckers. We will now begin the affirmative case and hear from the affirmative's first witness. Counselor, you may call your first witness.
Our first witness is Jaspreet Chowdhury. Hello. Could you please introduce yourself and briefly describe your professional background and where you work?
Sure, I'd be happy to. My name is Jaspreet Chowdhury. I'm the Senior Legislative Counsel at Compassion and Choices. My current work involves working across the country to review, draft, and implement proposed legislation related to end-of-life care and access.
Thank you. So our first question, in jurisdictions with medical aid in dying, what safeguards are in place to ensure that vulnerable populations receive the health care options they need?
Thank you for the question. I'm excited to dispel some myths that have been purported about how medical aid in dying actually works. A key safeguard is that the patient initiates the process from the start to the beginning. And it's not a single step in order to access medical aid in dying. There is a multi-step process, which involves multiple requests, including and involves an assessment from their healthcare provider that they are qualified for medical aid in dying, which includes an assessment of mental capacity to make an informed healthcare decision, which means that they understand the pros and the cons of choosing medical aid in dying. There's also multiple opportunities from the provider given to the patient and at multiple times in the process for the patient to change their minds. In addition, the attending provider also has to inform the patient of all other end-of-life options that may be appropriate. Finally, the qualifications are also confirmed by another provider. So it's not a single visit with a checkbox.
There's frequent oppositions coming from individuals claiming disability rights and access to medical aid in dying are in conflict. How does access to end-of-life healthcare options align with disability rights?
So the end-of-life movement and the disability rights movement share a lot in common, including a shared value and aspiration for self-determination and self-autonomy. Access to the full range of end-of-life options reflects a respect for personal autonomy for all individuals, including those from vulnerable populations and people with disabilities. It's also important to note that all laws that authorize medical aid in dying have language in them that says no individual is qualified for medical aid in dying solely because of advanced age or disability. I want to also say that another safeguard related to medical aid in dying that I didn't say before is that the patient, it's not saying that the patient makes the decision in isolation, but it's an opportunity for a patient to have a conversation with their community that includes loved ones, healthcare providers, faith leaders, to create an end-of-life experience that aligns with their values and beliefs. Those with disabilities also deserve the right to have that experience. And by saying that solely because a person has a disability, there shouldn't be access to medical aid in dying, or because there's problems with the healthcare system that results in inequities in all stages of life, including at the end of life, that a particular option should not be authorized is not the way to solve that situation. It's just a both-and situation where, yes, we need to solve and work to address healthcare inequities in all stages of life, and we also need to ensure that everybody has access to the full range of end-of-life options.
Do the safeguards you have mentioned work well?
Yes. So the safeguards are working as intended. There hasn't been a substantiated case of abuse or coercion. Additionally, there are, because of the multi-step process and reporting requirements, there has been almost 30 years of data about how medical aid in dying is working. And that shows that the laws are working as intended, which is to provide a group of individuals who have a terminal illness with a 6-month prognosis an opportunity to end a painful dying process.
Have the patients with the choice in their dying process, do the patients value their autonomy?
Yes, I would say that they do. I can't speak for all patients, but yes, they value autonomy. Anecdotally, we have heard that there's peace of mind from knowing that the option exists, whether or not an individual chooses it.
Is there a difference between medical aid in dying and suicide?
Yes, absolutely. Suicide is a public health problem that requires a societal collective response to address, and it often occurs outside the healthcare system. Medical aid in dying is an established medical practice that, as I said before, has a multi-step process, occurs within the healthcare system, and allows individuals to work with their healthcare providers, their community, to create an end-of-life experience that aligns with their values and beliefs.
Do you hold that the autonomy that these individuals are being able to show is something that we should value in our country?
Yes, I believe that patient autonomy and patient-directed care is something that should be centered in healthcare.
And typically, how long will it, when people are going through this process, does it take, is it a lengthy amount of time for people to?
I would say, I'm not sure, lengthy is kind of it depends on your perspective. So I would say that the process is not short. The implication that it is it's something that can be accessed quickly is a myth. There is a mandated waiting period, and also has been said, since the process is voluntary for both providers and patients, it does take time to go through all of the appointments and to meet all the requirements. So I would say that I don't know if it's lengthy, but I know for sure that it is not short.
It's not as short as what people are thinking that it is. It's something that takes time.
Correct.
Okay. And there's already a lot of safeguards that are in place. Are there any other ways that physicians try to make sure that this isn't something that they're regulating, that they're being able to make sure that the people who want it are receiving it?
So there are strict eligibility criteria for who can qualify for medical aid in dying. Again, it's a mentally competent adult with a terminal illness and a 6-month prognosis. And I think that the experience of the provider is best explained by Dr. Barnard, who's our other expert witness.
How do we make sure that the patient is mentally in a good mental state to make these types of decisions?
So again, I think our physician expert can speak more to that, but I'll say that as part of physician training and as part of every encounter healthcare providers have with their patients, not just on end-of-life care, there is a mental health assessment. And it is part of physician training to ensure that individuals who come to them understand what treatment they're seeking, what has been said, and made sure that it's understood. So that training is part of physician training.
And with the states that do recognize medical aid in dying, the regulations and the legal statutes that those states have, they have a lot of those regulations that physicians should follow.
So all medical aid in dying laws are subject to existing federal, state rules and regulations, including those that dictate medical practice.
Sorry. How many states currently offer medical aid in dying?
So medical aid in dying is currently authorized in 10 states and the District of Columbia. So we usually say 11 jurisdictions because the District of Columbia is not a state yet. Sorry, couldn't resist. Okay.
So since all of these jurisdictions that recognize it, are their medical aid in dying laws pretty similar?
They are pretty similar, and all of them have the same strict eligibility criteria, and that has remained the same from the first state that authorized medical aid in dying almost 30 years ago until now. There are some variations in the laws, but all of them have a multi-step request process, and all of them have safeguards.
And from your knowledge, from what you've seen with these, with the laws in these particular jurisdictions, have you seen much variation within how, like, the process that they're doing it? You say they're all very similar, but you haven't seen it change from when they enacted it until now, till recent times?
I think I need a clarification of what do you mean with variation from now till recent times?
If from when it was first placed into the state, if they've ever loosened some of their regulations with it.
So there have been changes to the law, but they don't loosen the regulations and they don't change the strict eligibility criteria. There's a difference between a safeguard and a barrier, so all the safeguards have been in place. The changes to the laws have, some have reduced the waiting period, but that change has been based on data that showed terminally ill individuals would die before the waiting period ended. And so those laws have been changed. And with the provider shortage, there's been an expansion in some places of the types of providers that can participate. But in all of those places, the providers who can participate are allowed to do so within their scope of practice. No providers can participate if it's outside their scope of practice.
So you would say that in order for them to get a mental assessment, it would have to be through someone who can do that.
Correct.
Okay, thank you.
Thank you.
The negating side may now cross-examine the witness.
Okay. Thank you so much for joining us today. So we'll go ahead and jump right into this. There was a lot of talk about safeguards, and so that's where much of our discussion will lie. Compassion and choices. Your organization, are they involved in lobbying efforts throughout the states?
Lobbying efforts to,
To support medical aid in dying.
yes.
Okay. And so that got me thinking, if they're involved in lobbying efforts to lobby in support of medical aid in dying, is it plausible that other lobbying groups could lobby against these safeguards that you talk so much about, perhaps loosening them?
I would say that there's passionate advocates in favor of authorizing medical aid in dying, and then the groups, the national groups similar to Compassion and Choices, who advocate or participate in the conversation on medical aid in dying, are often those that are opposed to medical aid in dying being authorized.
Okay. Are you aware of any instances where these safeguards had successively been loosened, or at least attempted to be loosened a little bit?
I'm not aware of any successful attempts to change the strict eligibility criteria or to remove safeguards.
Okay. Well, I can list off a couple in California, and they hinge mainly around this waiting period. California in 2021, they shortened the waiting period from 15 days to 48 hours. Oregon did the same thing.
If I may, sir?
Yes.
Again, that's a difference between a safeguard. There's a difference between a safeguard and a barrier. Your question was about safeguards. And what I said was that a safeguard is the waiting period still remains. The length of the waiting period is not the safeguard itself. It's the existence of the waiting period that's the safeguard. And those waiting periods were shortened based on data that showed individuals were dying before the waiting period expired. And there is not a value add to having individuals die because of a length of a waiting period. So when those laws were changed to reduce the waiting period, it was in response to data that was reported and collected, and not in response to saying that they shouldn't have safeguards in place. And the waiting periods do still exist.
They do exist, but they're drastically reduced. And I mean, additionally, and we'll get away from waiting periods. In Oregon, 2023, they removed the residency requirement, I believe, or sorry, yeah, Oregon removed the residency requirement.
Yes, and they also removed the residency requirement in Vermont. And I'll say that the health care that people can access should not be dependent on where they reside. And there is no other health care that's dependent on where you live. And so medical aid in dying is part of health care and should reflect that. So having a residency restriction removed aligns medical aid in dying more with other healthcare options and integrates it more into the practice of medicine. There's also active litigation right now in New Jersey to address residency restrictions.
I mean, perhaps maybe it lines it with other areas in the medical practice, but it still doesn't negate the fact that we have these robust safeguards, these waiting periods, these things, these residency requirements are all of a sudden getting slashed. What goods or safeguards that are so easily removed or reduced?
Safeguards that are easily removed and reduced are not as effective. But as I said, a residency restriction, a certain length waiting period are not safeguards. They're barriers to care. There's no other healthcare practice that has a residency restriction. And there's not a correlation between having an end-of-life that end-of-life experience is somehow safer because there's a residency restriction. So I negate the premise that those are safeguards. They are barriers. There's no safeguards that have been removed from any medical aid in dying law.
Okay. We'll agree to disagree a little bit. We'll move on to another area. We'll talk about doctors' involvements, and we'll mainly hinge around Oregon. Isn't the fact that you can go to any doctor in Oregon, not just your primary care doctor, but any doctor in Oregon to request medical aid in dying?
So there is, if you look in the definition of the law in Oregon, there is a definition of an intending provider, And I believe that it says an individual that is charged with the care of the patient's terminal illness. I don't have the law in front of me right now, and I have a good memory, but it's not perfect, so I don't know the exact language. But it's not any provider that can be the attending provider. I do know that.
Okay. Are there any states where it can be any provider?
No, there is not.
Okay. Well, then let's pivot a little bit and talk about psychiatric evaluations in Oregon. Is there a mandatory requirement for psychiatric evaluations for individuals requesting end of care?
There is, if either the attending or the consulting provider believes or has any concern that an individual is not able to make an informed healthcare decision.
Okay, the attending provider, the doctor, who's not a therapist or a psychiatric trained
So
person?
again, as part of physician training and practice, there is constant evaluation of a patient's capability and ability to understand healthcare decisions. So if that provider, as part of their training, believes or has any doubt or concern that a patient cannot make an informed healthcare decision, they are mandated to refer. And it's the same thing with the consulting provider. In Oregon, it's also a physician.
Okay. Well, that sounds nice in theory, but the numbers tell us otherwise. By 2022, only 1% of the individuals in Oregon seeking medical assistance and dying were referred to psychiatric evaluation. So are you telling me these people who are faced with these suffering, unimaginable illnesses, suffering both physically and mentally, aren't plagued with psychiatric issues, only 1% of them?
I'm saying that I trust providers, and that as part of the practice of medicine, if the provider believes that the individual is able to make an informed healthcare decision, I trust that. And I also think that, if I may push back a little bit on the premise that there were so few individuals that were referred for a mental evaluation that indicates a problem, it would be that low number doesn't indicate a problem. It could indicate that it could indicate that physicians have a relationship with their patients, that they know them well enough that they don't need the evaluation.
Okay, I see we're running out of time. I'll go ahead and sit back down, but I appreciate it. Thank you so much.
Thank you.
Thank you. We will now move on to the affirmative second witness.
We call Dr. Diana Bernard. Alrighty, thank you for being here today. We appreciate your time.
Thank you. It's a pleasure to be here.
To start off, could you please introduce yourself and just briefly describe your professional background to us?
Sure. My name is Dr. Diana Barnard, and I am an associate professor of family medicine at the University of Vermont Medical Center, and I am also board certified in hospice and palliative care, which I have been practicing for the last 15 plus years.
Thank you. To start off with the first question, so why shouldn't we just focus on making sure people have access to palliative care and hospice?
So the short answer is we need both. We definitely need more access to palliative care and more access to hospice services and more access to a broad range of services for those that are nearing the end of life. We also need more access to the tools to treat the suffering and the symptoms that we see with those very patients that are accessing that service. So let me step back and give you a little background. Bear with me. In 2025, today, the way we die looks very different than it did, say, 100 years ago, when most of us, actually many of us, died young or suddenly or from accidents or infectious disease or illnesses that we had very few tools to treat. So modern medicine has now made it possible for many of us to live much longer, and that's to be celebrated. Many of us live much longer with more advanced illness. That is to be celebrated. That very success brings up the issue of the fact that most of us now are going to face the final phase of our life with a higher burden of disease. More disease means more symptoms. More symptoms means more suffering. And so what we also need is to develop more tools to treat that suffering, which can be quite complex and quite lingering and very difficult to treat when it comes at the end of life. I have cared for thousands of people with terminal illness, and I've personally watched hundreds of people die. And I can tell you that every death is unique. It is a deeply personal and private experience. Likewise, the experience of suffering that people feel is deeply personal. Medical aid in dying is really about honoring that diversity and respecting the fact that we have different values and goals that we have lived throughout our life and that we bring to the dying experience. And we want to honor that diversity by having a range of treatment options from which patients can choose what is best for them during their one end-of-life experience. I think it's so important to understand that when people want to live. When people are diagnosed with a serious illness, they focus on treatments that will cure the illness, and when that isn't possible, they focus on treatments that will extend their life and hopefully extend the quality of their life. Excuse me. But inevitably, illnesses progress, and as illness progresses, symptoms become more challenging and they increase. And it is really only when treatment options are either completely exhausted or come with unimaginable or unacceptable consequences as the patient defines them, that people then shift their focus to preparing for the end of their lives and preparing to die. Mm-hmm. We all die. Sometimes we see death as the enemy, but it isn't. Dying is not the enemy, but people want to say in how they die, and how we die matters. It certainly matters to the person who's going through it, but it also matters to those that love them and care for them and bear witness to that dying experience. And when it's traumatic, many people bring that trauma forward to their own dying experience. So again, medical aid in dying is about respecting the diversity of values and goals that patients come to the dying experience with and having options so that people can make their own individual choices. It's really important to understand that the patient is in charge. As we heard from our other witness, the patient is in charge through the entire process. They have multiple steps to go through. There is a mandatory second opinion and mandatory reporting for every patient that I write a prescription for. That is not true of anything else that I do in medicine. In respect for the diversity of opinions, it is also completely voluntary. There are people for whom the option of medical aid in dying will never be an option, and that is okay. There are other people who are pretty sure they would want the option. The truth is, most of us don't know. Most of us do not have the luxury of a crystal ball that can look into the future and tell us what is going to be the cause of our death. What kind of suffering are we going to experience? But I can tell you that most people, when they're in that moment, they want a lot of what I like to call tools in the toolbox. When I am meeting with a patient and they are suffering, my job is to listen to how they suffer and to do whatever I can to help treat that. And medical aid in dying is one of those tools. I think the other thing that people sometimes forget is that people that are considering medical aid in dying, because that is what's happening. First of all, people think about their dying from the time they are diagnosed with a serious illness. That is not something that comes up just at the last moment. They consider it for a long period of time. And when they come to the point of thinking about their end-of-life experience, there are some whose suffering will be either well-managed or they find meaning in it, and others that suffer needlessly. Because death is not a failure. Death is not the enemy. Heads up, death is a part of the life cycle, and it's going to happen to all of us. Suffering is the enemy, and that's what we're trying to prevent. So it doesn't matter how much hospice and palliative care we have, there will still be those who suffer, and we need tools to address that suffering.
Thank you. My next question is, physicians take an oath to do no harm to patients, as we are all aware. How does medical aid in dying fit in with the oath to do no harm?
That is an excellent question. I think there's two ways to look at it, so bear with me. So the first is this concept of an oath. So we hold physicians to a very high moral and ethical standard, as we should. And every person who graduates from medical school takes an oath. Many people are familiar with this thing called the Hippocratic Oath, which was written by Hippocrates, by the way, very impressive document from the 5th century BC. So a few things have changed since then. And likewise, the oath that we take has changed since then. When the American Medical Association decided that they wanted to have a standard approach to a code of ethics, it was in the mid-1800s that they developed a code of ethics, which has been reevaluated and adjusted over the years as medical science has progressed and adjusted. And the most recent reevaluation of that code of ethics was in 2016. And that was after a multi-year process with very robust and deliberative debates and the input from many people, both in the medical field and without the medical field. And in that adoption in 2016 was a full acknowledgement of the moral tension that exists between those that believe in medical aid in dying and those who do not believe that it fits within their moral ethical code. And the AMA Code of Ethics now says that physicians on both sides of that debate can practice within their own personal moral and ethical code. And that, of course, is reflected in the fact that medical aid in dying is completely voluntary, not only for patients, but also for physicians. So if it does not fit within your moral and ethical code, you do not participate in the practice. And if it does, you do. So that's one arm. The other arm is this concept of what is do no harm, right? What is, going back to Hippocrates for a second, since we started there, there's the duty to help and the duty not to harm. But what is helping and what is harming is much more nuanced than any of us would like to believe, patients and doctors alike. And physicians should never overestimate their ability to heal, nor underestimate their ability to do harm. So let's pick a practical example of mechanical ventilation, putting people on a breathing machine, which no doubt has saved thousands and thousands of lives over the years. Well, we get to the 1970s, and suddenly we're having very intense debates about the ethics and the morality of mechanical ventilation and whether or not can you not use it, or if you start it and it's not helping, but it may be harming, is it okay to stop? What we learned from that experience is who defines help versus harm is not necessarily the doctor practicing medicine, but the patients and the families experiencing the process. So that taught us that what can help can also harm. Again, in the 1980s, we had a similar experience when it came to artificial nutrition. It's something that has helped prolong life and save lives in many situations. But there are situations where people using artificial nutrition were not being helped, and their loved ones or the patient experiencing it felt like they were being harmed. And we had robust debates about whether or not, once you start, can you stop? What's helping and what's harming? I believe medical aid in dying, and many other physicians believe medical aid in dying falls within that same framework. So for some people, prolonging life is the primary goal. And anything that we do to prolong life for a few more months, for a few more days, for a few more hours, is within their values and goals, and we honor that. For other people, they prioritize quality of life. That is what's most important to them. And when it comes to the very end of their one life and facing their one death, prolonging that process by a few days or weeks or even short months is a form of suffering. It's not consistent with their goals and values. And so, again, the concept of do no harm and trying to help is an evolving subject, and it is defined by the patient.
Thank you. That's all the time we have for you.
Thank you. The negating side may now cross-examine the witness.
I've never been cross-examined before.
Okay, let's get right into the questions. You have a specialization in family medicine, correct?
Yes,
And a large part of your work has focused on palliative care, isn't that right?
yes.
And just to be clear, you're not a psychiatrist.
No, but part of my basic medical training includes a variety of things.
But you have not completed a residency for it.
I have not.
And you do not hold any board certification or in psychiatry or psychology.
I do not.
Okay. And would you consider yourself an expert in detecting depression, anxiety, PTSD, schizophrenia, or other conditions?
My basic medical training prepares me for evaluating a lot of things, including those diagnoses. And I think the question that you're really asking, and perhaps what people are getting confused about, is the issue of whether or not a mental health evaluation should be part of the process of medical aid in dying. What's important to keep in mind is this. It is part of my routine care every day to evaluate a patient's ability to understand the treatments that I am going to offer them, whether it's prescribing a medicine, ordering a test, sending them to the hospital. My job is to evaluate that person to see if they are capable. Can they understand what they're asking for? Do they understand the risks and the benefits? Can they describe to me what the alternatives are, and do they understand the consequences? It's something that I do every day. When it comes to medical aid in dying, the purpose of the mental health evaluation is if the prescribing physician or the consulting physician has a doubt about whether or not the patient is capable. If there is a doubt, then additional exploration and evaluation is mandatory before we can move forward. The reason it happens so infrequently is in the vast majority of times, I can make that assessment myself, and it is obvious to me based on my experience and skill when a patient is not capable, and the process simply stops. And I explain to the patient why they are not eligible, and we look for other ways to address their suffering.
However, isn't there still a risk that someone who is clinically depressed or suffering from another condition could still be overlooked and misjudged?
Nothing in life is perfect, and the reason that there are careful safeguards is so that the process is deliberative and we have the opportunity to ask and explore with the patient on multiple evaluations what it is that they're worried about, what it is they're suffering with, and be able to act and treat. And again, at any point along the way, if the patient's judgment is impaired, the process must stop.
Let's move on. Do you agree that people can be excluded from receiving aid in dying, especially if they are not able to self-ingest the medicine?
Yes, we've heard a lot today about safeguards. And one of the safeguards, kind of the ultimate final safeguard, is a requirement that a patient self-administer the medication. That is what says, this is my final act and I do it of my own free will.
And do you believe this exclusion is fair or equitable compared to other terminally ill patients?
Medical aid in dying is one. Remember how I was speaking before about the tools? It is one tool. And in order to make it available and safe and have adequate protections, it's not going to be the answer for everyone. There are people who will suffer who are not eligible for medical aid in dying or for whom self-ingestion is not possible and it's not an option. So I will again say that we need many tools and more tools to address the very complex and many ways in which people suffer and the abilities that they have to be able to participate in medical aid in dying.
And would that legislation be able to be amended to remove that safeguard in the future?
Any legislation, by definition, would have to go through the legislative process. And so nothing in the law would change without a robust debate, similar to what we are having right now, to discuss the merits of such a change.
And wouldn't removing that safeguard, in effect, allow for others, including medical professionals, to play a more active role in ending a patient's life?
I think that sometimes pointing to the extremes of the outliers on what I like to call the bell curve of life, because pretty much everything we do has a range. And what you are talking about are things that are on the very outskirts. What I am talking about is the practical reality of how medical aid in dying is practiced. And it does have strict safeguards. And it's not available to everyone. And sometimes I have to explain that to patients who are not happy to hear it.
So on the topic of reality, let's move on to Oregon. Are you familiar with the Oregon's Death with Dignity Act?
Yes.
And can you agree that the Vermont's aid in dying law was modeled similarly after that act?
Yes, because the Oregon experience was so robust at the time that we were working to pass our law in Vermont, we relied heavily on their experience because even at that time, which was after about 10 years or more, we already had data that it was working well and as intended. And so our law was patterned after that law.
And isn't it a fact that Oregon has made several significant changes to its law since it was passed?
Well, I'm not a legislator, but I've come to learn a lot about laws, and we know that many laws over time have to be adjusted or amended. The core safeguards for the practice of medical aid in dying have not changed and remain in place. As has been discussed previously, there has been robust experience showing that, again, remembering that patients want to live and they focus on living and they only think about their dying and in some cases think about wanting their option of medical aid in dying when they are very sick. People wait very late to ask for medical aid in dying. And the experience of somebody who very much wants it, who then dies going through the process, shows you that maybe we are not talking about a safeguard, but we are talking about something that has become a barrier. And over time, some laws have been amended to reduce an unnecessary barrier that does not affect the core practice of what we are doing.
And are you aware of the data showing that in Oregon, a small number of physicians write the majority of aid in dying prescriptions?
I'm aware of that data. I'm also aware of this data, and you can look it up yourself because there is a very robust website with lots of data for the entire course that medical aid in dying has been legal in Oregon. If you look at that data, what you will see, and it kind of makes sense, medical aid in dying was a new practice, so not very many doctors prescribed. Over time, as people learned about the practice and educated themselves and gained experience, the number of people who prescribe for medical aid in dying goes up and has continued to go up. And I'm sorry that I can't remember the percentage, but a very high percentage of doctors practicing medical aid in dying in Oregon have only written 1 or 2 prescriptions.
Thank you. That is all the questions.
Thank you.
Well, that marks the end of the affirmatives case. We will now hear from the negation's first witness.
We would like to bring up Jason Ribley, please. Good evening. Could you please introduce yourself?
Hello, I'm Professor Jason Ribley. I teach in the philosophy department here at KU.
And what is your educational background?
I received my BA in philosophy from DePaul University in Greencastle, Indiana, and my PhD from UMass Amherst. I have been teaching philosophy since 2005, and I've taught the medical ethics course at several institutions that I've worked at. Starting at the University of Massachusetts, but at Colby College, the University of Maine, California State University, Long Beach, and here at KU.
And how does your knowledge and experience apply to today's topic?
Well, my background is not in the law per se, but in ethical, moral, and political philosophy. I have read extensively on this topic, the philosophical debate on it going back to the 1990s, and I'm familiar with many of the arguments both for and against the legalization of medically assisted death.
And what materials did you consider in preparation for your testimony?
Well, in addition to the articles that I've read and used in the classroom over many years, I did have a second look at this document that was produced in 2019 by the National Council on Disability called The Dangers of Assisted Suicide Laws, because there are a couple anecdotes and cases in it that I think are illustrative.
And did this lead you to form any conclusions on the resolution?
It did. I think it would be premature to legalize physician-assisted death nationwide at this time, even though I support its legalization in principle. I think in an ideal world, people with late-stage stomach cancer or brain cancer ought to have access to medical assistance in dying. If a person's rational agency is deteriorating or disintegrating, and there's no possibility of its recovery, and if the person's also in tremendous or even unmanageable pain, then I think that they have the right to end their life through physician-assisted death. I don't think there's anything morally wrong with that, and I think it's within the scope of medicine. But, as Immanuel Kant once wrote, the laws must be designed for a race of devils. We need legal rules and regulatory practices that both protect individual autonomy, which is very valuable, and that promote and protect human well-being in general. And I don't think we've yet found an adequate legal framework or set of regulatory practices. I think that states like California and New Jersey have rules that sound pretty good, but there are still problems. And I think the problems fall into three basic categories. So in some cases, the laws are fine. The laws are roughly as they should be, but they aren't properly enforced. A second issue is that some laws need to be revised. And then I think that there are some problems that concern our healthcare system as a whole that make it more problematic for us to embrace this practice than it might be for countries like the Netherlands or Switzerland.
Let's begin with the role of insurance companies. What role do they play in medically assisted suicide?
Well, this is a good example of a case where laws are not adequately enforced, in my view. California law prohibits insurance carrier communication from including both the denial of treatment and information as to the availability of aid in dying drug coverage in the same communication. They're not supposed to do that. It's against the law. It's been against the law since 2015. However, there have been multiple reports of this happening, and there don't seem to be any legal consequences or penalties for the insurers in these cases. And so I find that disturbing. I think it's morally wrong to nudge people into choosing physician-assisted death when they don't really want it, especially when they're in a frightened and anxious state of mind because they've just been denied coverage. In particular, I mean, also in Oregon, there's some peculiar laws there concerning the state Medicaid agencies, extension of coverage to people who need cancer treatment but have a prognosis of 5 or fewer years to live. And there, too, there have been disturbing reports of people choosing physician-assisted death after the state Medicaid agency has denied treatment. And so I think that kind of choice, it's not the same kind of choice that, for example, Brittany Maynard made in a famous case in California where no treatment was available given the nature and severity of her condition.
And there is a worry that the problem is unmet support needs, not terminal illness. What factor does unmet support needs play into medically assisted suicide?
Well, I think that unmet mental support and treatment needs, as well as just basic unmet physiological health support and treatment needs, that becomes a big worry when you consider the issue in a broader context. Because first, this language that we've heard before about a terminal condition with 6 months prognosis, that's vaguer than it seems. It's more vague than it seems. Does that mean with or without proper treatment? A lot of things are potentially terminal without proper treatment, even type 1 diabetes. I think that it may be worth experimenting with something like this. Probably we could enumerate the common diseases with well-established terminal predictions that are agency-destroying and very painful, and that might be better than having the current language, because that's really ripe for abuse, I think. Anyhow, if you take that into consideration, and then you also consider, which we've already heard about, that something else that we've already heard about, that many states require a psychological or psychiatric evaluation only if the main physician has concerns about competence, I think that those two things together suggest that there's going to be a significant number of people who choose physician-assisted death in the face of an uncertain prognosis because they have unmet mental health support and treatment needs. And here's why. The competence test is fairly easy to satisfy. The MacArthur Competence Assessment Tool that's commonly used in the United States, as other people have reported, it asks the patient, what does the doctor say is wrong with you? What are the different possibilities in terms of treatment? What are the probable outcomes of those different treatment options according to the physicians? What are your values? How do they inform the treatment that you've selected? And people who have conditions that I think it's fair to characterize as forms of mental illness can pass that test. It's not meant to screen for depression, and in some ways I understand why it would be inappropriate to screen for depression. There may be some individuals who are depressed who also have terminal painful illness who actually ought to be considered as candidates for medical assistance in dying, in my judgment. But there's a lot of things that the current competence test does not screen for. Somebody could pass that while having a very unusual set of values that's perhaps been warped or distorted by traumatic life events or mental illness.
Okay, let's move on to the ethical side of the current laws. What problems do you see with these current laws?
Well, I think at a very high level of abstraction, the ethical problem is this, that we don't always enhance a person's autonomy by giving them additional options. If there's a chance, or reason to think, I should say, that this is going to lead to them making a bad choice. Autonomy means rational and informed self-direction. It doesn't just mean getting whatever you want. And so just as you don't increase people's autonomy by giving them the option to take out payday loans at high interest rates, I think that maybe you don't enhance everybody's autonomy by giving them the option of physician-assisted death, at least not with some further laws and safeguards in place. And I don't know what those should be. I'm not a legal expert, but another possibility that needs to be explored, I think, is that there needs to be some kind of outside party involved in this, in the evaluation or the supervision of this practice. In the Netherlands, for example, where they do practice physician-assisted death for severely disabled newborns, every case is reviewed by the prosecutor's office, and so there's a mandatory legal review by people outside of the medical profession, but nonetheless with special training that allows them to look at these things and to evaluate whether appropriate decisions were being made. So I don't know if it's the state health department or if the state needs to hire doctors and psychologists for this purpose, but some kind of oversight from somebody who's not in the employ, so to speak, of the patient, I think would improve the law around this.
And how feasible would it be to have medically assisted suicide laws without it getting out of control?
Well, I don't know. I mean, I don't want to overstate the evils of the status quo. I don't think that the law should be reversed in California or New Jersey. I think it needs to be tweaked and modified in certain ways because people with various late-stage cancers, as I said, I think they have a right to seek this treatment. They would be harmed and indeed wronged if we took that away from them, but I see a lot of other ill social effects, negative consequences if the current regime is just taken nationwide without any further modifications.
Thank you. That is all the time we have for questions.
Thank you. We will now hear an affirmative cross-examination.
Hello, Professor Rively.
Hello.
Thank you for being here today. My first question is, obviously you're aware that primary care physicians are trained to screen for mental capacity, and they are legally required to refer patients for psychiatric assessment if they observe any indicators of an impaired ability to make rational decisions, correct?
I understand that they have some training in this capacity, but psychological assessment and diagnosis is complex, and many psychologists will tell you that they can't reliably judge whether a person has clinical depression, for example, or bipolar disorder, even after having a full 45-minute or hour-long session with them. So I think, if the physician has an ongoing relationship with the patient, that's one thing. But as we've heard in Oregon, the physician-assisted death is sometimes being prescribed by doctors that the patients have found when their ordinary practitioner did not want to help.
So do you believe that physicians who are experts in mental health evaluations can still be fooled by a patient who's suffering from something or they have limited mental capacity? Do you think they can fool them as well?
Someone who's going to be an expert in psychological and psychiatric diagnosis would be a psychologist or a psychiatrist. And so if a physician had that training in addition to their normal training, and they had the opportunity to meet with this person and observe them and ask them questions for several hours, then I think it's unlikely that they would be fooled by the patient.
Okay, thank you. So if doctors on a regular basis are trusted to assess one's capacity for major surgeries and other psychological treatments, why shouldn't they be trusted to assess the capacity similarly in the context of medical aid in dying? Do you think that in other circumstances, when it comes to major life-altering surgeries and other psychological treatments, that again, every single instance, a patient ought to be referred to a mental health professional?
Frankly, I have general problems with the competence assessment tool that's commonly used when in other high-stakes situations as well. There's notorious sort of horror stories about this in the medical ethics literature surrounding anorexia and bulimia, surrounding bodily integrity identity disorder, where people they're pursuing elective amputation. They can pass the competence test with flying colors, but there's reason to suspect that there are other healthcare needs that are not being addressed properly.
Thank you. Moving on, you mentioned instances when insurance companies denied treatment but approved medical aid in dying. Would you agree that this is generally more of an indictment of our insurance system rather than aid in dying laws themselves? Similarly with mental health capacity assessments, it seems like you have more trouble accepting the way that our mental health works and the way our healthcare system works rather than the issue at hand.
There's some truth to what you say there. I think that I would take the concern even broader. I think that the healthcare system in the United States, where we pay many times the price that they do in our peer nations like Germany and Japan and the United Kingdom and so forth, but get equal or lower quality care, that entire system is broken and defective in certain ways, and there needs to be systemic change. And if there was such change, then I think we could have greater confidence that people are really getting the best available treatment and support options, and that those are live options for them that they could really take advantage of if they wanted to.
So you agree that those with bad insurance or in a society with improper healthcare systems deserve a full range of options rather than being forced into suffering because of these insurance issues?
Yeah, I mean, I don't think that, I think the most rational, focused way to address the problem that I mentioned previously is that there would be some way of reporting communications from healthcare insurers that contain this kind of information, where there would then be some kind of legal consequences, monetary consequences, criminal consequences potentially for the insurance company. So I think that could potentially be addressed in a way that would satisfy me while having physician-assisted death as part of the law.
Mm-hmm. Safeguards were mentioned a lot tonight, and it was argued that a lot of the safeguards that are currently in place could erode. But would you agree that in every state where medical aid in dying is legal, expansions or adjustments to the law have required full legislative debate and public input?
I don't really know enough about the evolution of the law in certain jurisdictions to comment on that, but I will say this. In Oregon, the charge is not that the law has been weakened along every front over time. It hasn't been. Part of it is intact from when they originally wrote it. It's rather that, on the street, in practice, the obstacles to securing physician aid in dying, if you set out to do it, have gone away. There are fewer obstacles now, practical obstacles for somebody who wants to procure this than there used to be.
Are you aware that the exemptions to the waiting period, for example, that were mentioned earlier, are not automatic, but they must be approved by medical professionals first who assess the patient's prognosis and their physical state if they do want to take advantage of skipping that waiting period a bit?
I had heard that in the California context, but that's not the primary focus of my concern, yes.
Well, do you believe that a patient who is, let's say, 48 hours from death, but still fully mentally competent, should be denied the choice to avoid extreme suffering simply because of arbitrary time requirement?
Cleverly put, I would say that there's going to be some cases where people have advanced cancer and extreme pain, and the deterioration of their agency is truly imminent, where a 48-hour waiting period would be sufficient for them to size up the situation and make a rational choice. But the question is, what should the law be in general? And no matter how we write the law, first of all, we shouldn't formulate it or structure how the law is on the basis of kind of unusual cases that could occur. We should make it on the basis of cases that are likely to occur. But also we have to write the law in a way that balances various harms and benefits, both to autonomy and to well-being.
Thank you. So would you argue that it's morally right to force someone to undergo any other form of suffering, say an unwanted medical procedure, if it's deemed in their best interest by someone else?
People have the right to refuse treatment under most normal circumstances. However, there are exceptions even to that. I mean, if people are, if they fail the competence test for one thing, there can be grounds for overriding their vocalized preferences in, to promote their best interests.
If they fail a competence test that you think is incompetent?
Well, I think the competence test is too weak. I mean, but I'm on board for this. If somebody fails it, then yes, that's probably decent grounds to remove decisional authority from them. If they fail the current test, because it's very undemanding. It would to fail the current test, you would need to not really know what's going on with your health, or what the physician told you the treatment options were, or what the physician told you the likely outcomes of those things were. So, yeah, I think if a person fails that test, then we can perhaps override their decisional authority.
And finally, so would you agree at the end of the day that denying a mentally competent and terminally ill patient the option of medical aid in dying does in itself cause unnecessary suffering?
I would say that for some patients, yes, it does.
Okay, thank you. That's all I have for you.
Thank you. We will now hear from litigation's second witness.
We'll go ahead and call Ms. Michaela Pretzia up. Do you mind introducing yourself and talking a bit about your background and experience relating to the topic at hand?
I am Michaela Pretzia. I work with the Patients' Rights Action Fund, which is a national nonprofit secular organization committed to fighting the expansion and legalization of what we call, by its technical term, assisted suicide, in accordance with the AMA, as public policy, which harms vulnerable and historically underrepresented populations. We do this essentially by going to states and helping them form coalitions of concerned peoples to learn how to oppose these laws for the reasons that those specific states need.
All right, thank you so much.
Yeah.
Thank you for joining us. Do you mind briefly going over your top issues with medically assisted suicide? And then we'll go ahead and jump into each a little bit more further.
Great, yeah. So I have 3 reasons to share with you why assisted suicide is in fact dangerous public policy. The first reason is that contrary to claims that these laws are perfectly safe and that there's never been any cases of abuse, there are actually myriad examples of abuse, coercion, or mistakes that have occurred. In particular, I want to mention the fact that people who are not dying can receive these drugs, and people with psychiatric illness have received these drugs. The second major reason we oppose assisted suicide is because in our profit first, person second, or some people would say person last, healthcare system, offering lethal, cheap drugs alongside expensive, sometimes burdensome treatment is not actual autonomy. If you present a patient with the choice, either die peacefully, supposedly, or live as a burden, that's not a choice. Autonomy requires that you have several options. The third reason we oppose assisted suicide is because simply they are inherently discriminatory. While as a nation we seek to offer suicide prevention services to people seeking to end their own lives, in the case of assisted suicide laws, we carve out an exception for people who request it due to their disabilities that have come along with their terminal or serious illness.
All right, thank you so much. We'll go ahead and jump into the first topic, areas of mistake and abuse and coercions under the laws as written.
Great. So I want to share a few reasons why my organization opposes the laws as they stand, not merely for the things that they could become. The safeguards do not actually keep certain populations safe from harm and, in some cases, wrongful death. For example, you can have an inheritor be the witness for a request, and before you write that off as fanciful or coming from like an NCIS show, we do have the case of Thomas Middleton, who was diagnosed with Lou Gehrig's disease in 2008. He moved into the house of a woman named Tammy Sawyer, who he had appointed the trustee of his estate, and later that month died by assisted suicide. She posted his property for sale 2 days later, deposited most of the money in her business accounts, and deposited $90,000 in her personal account. And it took a federal investigation into real estate fraud to recognize that this abuse had occurred, because the Oregon Health Authority, which is supposed to red flag cases of potential abuse, did not notice that this case had any questionable elements. The next reason why we oppose laws as they stand is that people who are not dying have and can obtain these drugs for 2 primary reasons. Firstly, prognosis is notoriously inaccurate, actually, in fact, kind of by its nature, because it's an average of the length of time people live with this disease at this stage. Meaning, you might end up giving drugs to someone who could live months, even years longer than you would predict. For example, in a Chicago case, or at a Chicago study of 5 palliative care units, no one team was able to accurately predict the length of prognosis more than 50% of the time. And physicians in particular tended to underestimate the length of time a patient had to live. Another more complicated but very important reason why assisted suicide laws can end up giving drugs to people who are not dying is because under the law, technically, you can apply if you're a terminal without treatment, meaning that in Oregon, where we have the most robust data, we see diabetes, HIV, hernia, complications from a fall, medical complications, and as we found out recently, and which I'll discuss in a little bit, anorexia, as reasons why people have received assisted suicide. Taking diabetes as a reason, or as an example, this is not terminal without treatment. It is an absolutely imperative medical right to preserve autonomy to refuse treatment, but assisted suicide laws take advantage of this absolutely critical element of medical autonomy. To demonstrate the point, there's the case of Cody Sontag, who in 2003 was diagnosed with dementia, which is not technically, does not technically qualify you under the Oregon law. She had early stage. She elected to stop eating and drinking. It's called VSED. It's also your medical right. On day 5, her physician qualified her for assisted suicide, saying that she was terminal because she was dying from dehydration. On day 8, she died by assisted suicide. A proponent publication touted this case as a bridge for those patients whose diseases do not technically qualify them under the law, like dementia. And a proponent physician in that same article asked the question, if refusing to eat and drink makes you terminal, technically under the Oregon law, aren't we all terminal? And the answer is yes.
So you and I, as well as anybody else here, without any type of underlying illness currently right now, we simply just have to refuse to eat and drink and we'd qualify.
You would technically qualify, and the doctor could not be held liable for helping you assist in your suicide. The next major problem with the laws as they stand is that individuals with psychiatric illness have received these drugs. There was a really great study by someone who does a lot of work with the anorexic community. She found in 3 states, California, Colorado, and Oregon, that there are several confirmed cases of women in their 30s having requested, obtained, and died by these lethal drugs because they were told they had terminal anorexia, which is already a very contested thing to say in the medical community. But on top of it, technically under the law, you're not supposed to be able to get drugs for psychiatric illness. But this points out a problem with the law. The patient is not actually in control all the way through. The doctor is an incredibly important part of who gets and does not get assisted suicide. And in some cases, doctors are not the best caregivers. Finally, to kind of put an exclamation point on these problems, there is the reality of doctor shopping, which is what we call when a patient goes from medical professional to medical professional until they find someone who is willing to prescribe them the medication. This happened in the case of Kate Cheney, who went through 4 medical professionals before the final one signed off on her competency requirement, while simultaneously noting in his notes for the case that she might have been under some pressure from her family, and, quote, her daughter Erica seemed somewhat coercive. So to move on to the next kind of series of problems, which actually my partner mostly addressed, so I'm going to just say it really quickly. Assisted suicide is a lethal mix with our broken healthcare system. It's not a real choice if the person feels they can choose either to, again, go through a very burdensome, expensive process or choose this other lethal option. I want to say the length of days between, as recorded in Oregon last year, between when a person was prescribed and when they took the medication was from 0 days, so they died by it the day they took it, to 724 days, which is just over 2 years. This is just to point out there are some people who prescribe and take, and there are other people, contrary to the claim that everyone is imminently dying, who lived for 2 years and had these lethal drugs in their house for 2 years until they decided to take it. The final reason why we oppose assisted suicide is because the laws are inherently discriminatory, and I hope to help you understand this by pointing out 2 realities. So the top 5 reasons why people request assisted suicide in Oregon, which has been shown very clearly and consistently from the beginning. We use Oregon because it's the longest state, so that's why we keep referring to it, are all related to existential concerns that have come with their concerns with the disabilities that have come along with their terminal or serious illness. All very legitimate concerns: loss of autonomy, loss of dignity, loss of ability to engage in activities used to find enjoyable, loss of bodily control of your functions, like not being able to toilet yourself, for example. And about half list the reality of being, or the feeling of being a burden on family and caregivers as the reason they request. So we have this reality, right? People who are dying and want assisted suicide are confronting all of these new disabilities that have come with their disease that are very serious. Now, simultaneously, a Harvard medical affiliate hospital did an incredible national survey and study of physicians and people with disabilities. And they found that 80% of the doctors in the study rated people with disabilities' quality of life as lower than those people rated their own quality of life. Meaning, many of the doctors looked at someone with a disability and assumed that because of their disability, they were not as happy as they were. 40% of those doctors, only 40%, said that they could confidently care for someone with disabilities. In a system that clearly does not train most of its physicians to take care of people with disabilities, it is not increased autonomy to offer an option to people whose main suffering is their disability. If they're told falsely that they can either die with dignity or live in indignity, that is not a choice. That is one option. And so my organization seeks to defeat assisted suicide laws because the safeguards do not work and because they put certain people, especially people struggling with disabilities, at risk of harm, abuse, coercion in our medical system. Thank you.
All right. Thank you so much. That's the end of our time. Appreciate it.
Thank you. The affirmative may now cross-examine this final witness.
Hello.
Hi.
So we recognize that individuals with disabilities who are competent, they're able to make decisions about their own lives, of what they want to do, how they want to be treated. Isn't medical aid in dying no different?
Actually, most of the people with disabilities that we work with who join our coalitions, one of their main contentions is that they have a very difficult time getting what they want in the medical system because of the inherent bias in the system. That was one thing that study made very clear. The degree to which physicians assumed someone with disabilities had low quality of life blew other healthcare disparities out of the water. Based on race, based on sex, blew them out of the water. The thing we hear repeatedly is that people with disabilities go to the doctor with a cold. They ask for cold medicine, and the doctor asks them, "Are you sure? If you just forego that, then it could all be over for you." How can you say that offering death in a system where medical professionals, and I actually do not mean to be, I have two physician siblings. I know that doctors are incredibly important. However, it seems clear that in a system that doesn't know how to see people with disabilities as, worth their time and worth living, we should not have this option available.
Wouldn't you agree that having an option to do something, even if it's never utilized, it could still provide comfort for individuals in certain situations?
But I think the reality is that it is utilized by some, and it leads to abuse and coercion for others. And so in the case of public policy, you always have to consider which populations could be harmed, even by unintended consequences. And it seems clear that there are, in fact, populations who are harmed. And so while it might be a comfort to some people, if it means that there's death and harm to others, you cannot make it public policy.
But do you agree that states that do allow medical aid in dying with the regulations and protocols, then the protocols that are followed to ensure that these individuals are able to go through with this?
I don't agree that they work. I agree that they look good on paper. I think one of the reasons, again, they don't work is because when you legalize assisted suicide, you beg the question, who and what is a legitimate reason to want to die? And I think assisted suicide laws respond with, well, doctors are a big part of deciding who and what are legitimate reasons to die. And I'll give you an example. In a great publication called Cultural Anthropology, there was a woman, Anita Hanig. If you want to look up the article, it's excellent. She's just a journalist. She wasn't going with any pro or con opinion. But she interviewed a lot of doctors who have participated in assisted suicide in Oregon. And she talked to one doctor who told her about this case he had. And again, you can look it up to confirm everything I'm saying. Anita Hanig, Cultural Anthropology. He told her, look, this guy in his mid-30s came into my office, and he had 6 months left to live. He probably would have had a good quality 4 months, and he was asking me for assisted suicide. So I asked him, because the law told me to ask him why he wanted assisted suicide, and he said, I don't have any friends. I don't have a good quality of life. It's for social economic reasons. It's not pain. And the doctor asked himself, and he told this journalist, he was like, this was a tricky case for me, because isn't this the same as asking for suicide? But he referred this man to a competency test. Turns out he was perfectly logical. He knew all of the logical consequences of his decision. And so this doctor prescribed this man the assisted suicide drugs. And he said, no, that was a little tricky, but who am I to stand in the way between this man and what he wants? I mean, at the very least, I think if that man, you can say, if that man had gone into that office and did not have a terminal illness and asked the reported all those same things to the doctor would have referred him for suicide prevention services. But because of his illness, he did not in this case.
You keep referring to it as physician-assisted suicide, but you are aware that there's a lot of leading medical organizations that are opposed of using the term suicide and assisted suicide to describe the medical practice of aid in dying.
I am aware, yeah. And I understand because suicide is a difficult word. However, just like with the AMA, which defined it as physician-assisted suicide because they are technically the most accurate terms. In this case, actually, because now nurses can prescribe it, you should just call it medically assisted suicide. Suicide is someone taking their own life. In this case, the medical system assists them in taking their own life. This is why we call it assisted suicide.
But also, are you aware that the American Medical Aid Association has kind of allowed it? Because according to one of their reports, they're allowing physicians according to their dictions of their conscience without violating their professional obligations to perform.
They do say that at the end of that ethics report, but at the very beginning, in the first few sentences, if you want to read it, they say physician-assisted suicide is incompatible with the physician's role as healer. And they give two more reasons, I think, to do with putting people at risk. And then they go on to state, but we recognize that this ethics decision is coming out in a country with divided states, and we want to respect physicians' conscience. But the first thing they say is that as a body, after having discussed this for a long time, we do not, it is, incompatible is the word, quote, incompatible with the physician's role as healer.
Would you agree that a lot of your concerns are more in line with the regulations that are in place, like the protocols that are going on with the law, or the way a lot of it's handled, not necessarily the option?
I think that this option is not something that you can ever make public policy because it depends too much on human error. So it's just by its nature, it's offering death to patients who might need care, and it's utilizing the medical system to do this. And so I don't actually think in principle that it should be legalized for that reason.
But people are allowed to sign DNRs or have wills where they're specifically saying that they do not want to have any kind of treatment or to do anything in that nature if they are terminally ill.
That's true, but that's different from assisted suicide, because in the one case you're rejecting care, which is your total medical right? You're saying, if this happens to me, I do not want you to treat me this way. But I would contend that that's very different than actively enlisting doctors and pharmacists and other medical professionals to help you actively pursue a certain option.
Okay, I see we are out of time. Thank you.
Yeah, thank you.
Thank you. That marks the end of the negative case, and we will now move on to closing arguments. Mr. Duckers. Sure.
Before we close, because the program's going downhill from here, I want to recognize, as does my friend Pedro, Janera, Cass, Jaspreet, and Ryan. What an outstanding job that was. All right, now the two of us will return to our regularly scheduled bickering. All right, you can start running the clock. You know, when this topic first came up, wasn't really something I wanted to do because I thought for myself, you know, if I'm ever diagnosed with Lou Gehrig's disease, ALS, or Alzheimer's, or I have a massive stroke and I can't speak or move, but I'm still physically healthy and I'm trapped in this body for years like my grandmother was, I would like the option of ending my life. So I wasn't sure I wanted to take this on, but as I got into it, I discovered if I have Lou Gehrig's disease or Alzheimer's or have a stroke, I can't avail myself of doctor-prescribed death or medical assistance in dying because I don't have a 6-month terminal date. Pedro might say it's also because I'm not competent, but that's an entirely different issue. And I thought to myself, well, that's not fair. I mean, that is just not fair. Someone with Lou Gehrig's or Alzheimer's is going to suffer a lot more and a lot longer, for a lot longer, than someone with just 6 months left to live who can receive hospice and palliative care. Why are we denying this treatment to those people who are so deserving? Dr. Brainerd talked about easing suffering, and yet she doesn't afford this care to people with Lou Gehrig's disease or Alzheimer's who are suffering. That's not fair. And of course, the reason we don't do it is because we would end up putting that decision in the hands of someone else, and what was once voluntary euthanasia becomes involuntary euthanasia. But at that moment, when I realized that was not fair, I hit on a major reason why you must oppose this proposition. Because you will never, and we do not now, be able to put guardrails in place that work because there's always someone out there with a compelling case to make. And as you consider the feasibility of guardrails, and I think you heard enough in this testimony to understand those guardrails have eroded and in many cases are virtually non-existent, keep in mind three things, three aspects of the human condition. Number one, you may in your heart of hearts know exactly those circumstances in which you believe medical assistance in dying should be available. And in my heart of hearts, there are those circumstances where I believe it should be available. Now try reducing that to legislative language. Legislative language that encompasses the full range of possibilities and can also look down the road and around the corner at contingencies that may come up. It cannot be done. It's virtually impossible. But even if you assume it could be done, remember this: what is enacted today can be amended tomorrow. These fine people are from lobbying organizations, as is Michaela. They go to the legislature and say, change the law. And so if you have this law that provides for medical assistance in dying for just those who are supposedly terminal within 6 months, what happens in the next legislative session? The ALS, Lou Gehrig's people are in, the Alzheimer's people are in, the people that represent stroke victims are in, saying, we want to have that available to our constituency as well, and they are backed at that point by the most powerful argument you can use in America today, which is, this is not fair. You are not treating our people fairly, and that must change. The third thing to remember is, never doubt the ingenuity of the American people. There are thousands of pages of the tax code, and yet every year people figure out a dozen or dozens and dozens of different ways to get around those regulations, to evade the spirit of the law. And that's what you've heard in talking about these guardrails, which it's interesting, you know, when these laws were enacted, the waiting period, the residency requirement, limiting it to doctors were all important guardrails, but now, according to Ms. Chadhura, no, they're just barriers. They're barriers to expansion because, as you heard from Dr. Brainerd, that's what she really wants to do, is expand this beyond what you've heard in the debate tonight. On this issue, whichever side you come out on, you have to recognize that someone's going to be treated unfairly. I think it is unfair for a terminal patient who's suffering to not have access to this care. I also think it's horribly unfair for people to be able to have death prescribed to them by a doctor when that's not really what they want, when they're not competent, or when they're being pressured into it. So whichever way you go on this issue, someone's going to be treated unfairly. But I'll leave you with just this. If doctor-prescribed death is not legal, no one is going to wrongfully die. But if you adopt this proposition and make doctor-prescribed death legal in this country, there will be wrongful deaths. There will be wrongful deaths if you adopt this proposition, and that is perhaps all you need to consider in deciding where you are on this issue. Thank you.
There may be wrongful deaths. Give me a call. We'll sue that doctor and perhaps put that doctor in prison. We cannot use the extreme to deny our constitutional right to due process. The United States Constitution, 14th Amendment, protects individuals from being deprived of life, liberty, or property without due process of law. And the Kansas Constitution, according to Hodes versus Nasser, Hodes, Nasser versus Schmidt, protects individual autonomy. This right, the Supreme Court of Kansas stated, allows a woman to make her own decisions regarding her body, health, family, formation, and family life. The ruling established by the Kansas Supreme Court grants fundamental rights to one's own control of one's body. Get the government out of my decision to choose how to end my life. That is a personal choice. Lou Gehrig's an awful illness, but that Lou Gehrig's patient has the right to say to the doctor or the hospital, I want to stop hydration. I want to stop feeding. And that person will die. And when that person's organs become disabled, that person is terminally ill and has the right to qualify for the tool that Dr. Barnard described. Easing suffering. All of us are going to die. Shouldn't we have the right to choose what is best for us? That to me seems as American as it can possibly be. Choice is sacred to us. It's the foundation of freedom. Why should we be denied the choice of how to end our lives because of extremes? The anorexia case that my esteemed counsel pointed is a tragic case. A woman, which are the most likely to suffer from anorexia nervosa, was extremely ill because she had chosen not to eat. She was in extreme suffering. This is not some willy-nilly decision by a doctor to say, okay, anorexia nervosa, here, a lethal dose of medication. No, that's not what happened. This individual had a terminal illness because her organs were failing. And as a consequence, she qualified and was administered the relief she wanted. It is not up to us to determine how another should die. It is not up to us to determine what degree of suffering a fellow human being should endure. That is a decision between that patient and his or her physician. people like Dr. Diana Barnard, who has experienced this firsthand. You'll notice my opposition didn't have a physician. We did, because it was important for me to show you what the actual practice of medicine is like in those very last moments of one's life. So I urge you to give this thought, to give this idea greater consideration, and ask yourself, as I'm dying and I am suffering great pain, do I want that option? And should that option be denied to me because of extreme issues on either side? The answer is no. The answer is no. Autonomy is essential to freedom. Choice is essential to happiness. Thank you.
Well, that brings us to the end of tonight's program. I'd like to ask the audience to join me in thanking our wonderful counselors. Yep. Along with our expert witnesses, too, and our wonderful students. Thank you.